Hey guys, it's Kathy. I hope you're doing well. I got some crazy people today, crazy cases. One interesting case. Someone gets caught lying to two judges, I think. I don't know. We'll see. Someone who's harassed. Some that are just funny. But, okay. The first one says it all now. You're going to hear audio at the beginning that's a little bad, but that's part of it. You'll see. Just hang in there. You'll see.
73, 72. We're on.
Ready? All right. The court calls 2023 CR 2514.
That's
People
not how
versus
we
Perry Stokely. Entries of appearance.
Against my own rights, man. You're not.
Mary's autograph at the public defender's office for Mr. Stelling. I believe he's appearing virtually, but I don't know the visual.
You're not the one. You're not the one on the other side of this boat.
He's appearing virtually.
Okay. That is today for a review with the parents of the parties. I do see the latest update from the state hospital indicating that in about 30 days he has moved from 300 in the queue to 212. So there is some movement.
You gotta be quiet.
Are we set for the
How you
review?
gonna tell me?
Yes, Your Honor. But after incident
Right
report
now-
review, I did want to make a record on Mr. Stallings' behalf with his presence.
Okay.
Okay. We're not finna handle this like this, man. We're not doing it. You violate my rights.
Mr. Stallings, can you hear me, sir?
Your Honor, you violate my rights as of right now. We're not supposed to be on no little small monitor like this. We're supposed to be on a big screen where you can hear me and talk to me or you don't in court. This is violate my rights. You know it.
I can hear you and see you, sir.
Right now.
All right.
What?
Ms. Beldegraf, go ahead.
Mr. Stallings, first, you are on a big screen in the court, just so you know.
What did they say?
Judge, Mr. Stallings has conveyed to me that he wants to make the request of the court that he could either proceed pro se or hold a burglary hearing. I've explained to him that at this stage, given the situation and his competency, that that's not an appropriate step at this point, but I have promised to make that request on his behalf to the court.
Let them know.
So that the court hears.
Let them know to set this
Matter
court.
is pending
This right here, this here.
competency review, so
Let them know to set this here.
Mr. Stallings is denied.
Let them know to set this hearing right here,
And we
reschedule
will
this
set
hearing.
for further
And
review.
reset it for another day. Right now is not the time. We ain't supposed to be on nothing this small. We supposed to be on a bigger monitor or either I'm in court. We're not.
Set your next court date for in person, okay?
If you sit down, I can get closer.
All right. How far out did you want to
Here,
set,
man.
Ms.
Let him know
Beldegraf?
that I need to speak right now. Nobody else needs to speak. This is my rights being violated right now. I need to speak. Not nobody else at this time, but for him to hear me out and to just hear me out right now. We need to reschedule this. Who is that speaking?
All right, sir, we are trying to schedule another date for you to appear. So
Well,
give me
you know-
just a couple seconds here and we'll clear a date for you to appear again.
But listen, now it's not no again. There's no such thing as again. We're not gonna keep going over violate my rights. I'm not gonna keep sitting up allowing y'all to violate my rights. One thing.
All right, Ms. Beldegraf, do you have a date, 30 days?
For one thing, I'm on the side of a door, on the other side of a door. And the second thing, we're not on the monitor. We're supposed to be on a bigger screen monitor. Not
Okay, all right, does the 28th work?
That whole week is not
Oh.
for me. I'm sorry. How about the next week?
Why don't we
I can do the second.
All right, April 2nd at 9 o'clock.
We reschedule this right here, this hearing right as of right now. We need to reschedule this hearing. We're not finna sit up and have nothing. We need to reschedule this hearing right now. And another thing, because Where's my even the attorney? Where's the attorney at? She's on the phone. She don't need to be on the phone. She should have came here and talked
Ms.
to me.
Feldegraf, will you go to the podium so he can see you,
That's what she
possibly?
should do.
What's the next hearing for us? Mr. Stallings, can you see me?
Yes.
What you should
She's
have
beginning.
done is you should have came here and spoke and speak with me. That's what you should have done. You should have done from the start. You keep sitting up violating my rights. You violate my rights, my civil rights. That's exactly what y'all doing. Y'all know exactly what y'all doing, and I'm not gonna sit here and allow. Again, I need another court-appointed lawyer. I need another court-appointed lawyer. I do have that right. I know my rights. I need another court-appointed lawyer. That's what I need. I do not
I need
work.
your request
I
to the
no
court to be
longer.
denied.
I no longer. No, it's not. No, it's not. I no longer need you to court appointment. You're not doing your job. You don't do your job. I don't need you any longer. I do have that right to dismiss you. I do have the CRS is in here to. I'm
I'm going
allowed
to
to dismiss you.
talk more about it soon, Mr. Stallings, okay?
That's what I do know.
Mr. Stallings,
Stop and let y'all run
Mr.
over me.
Stallings, this
No,
is not going to be a
can't do what
productive
y'all want to
exercise.
do, man.
You don't
You understand that?
Stop talking
cannot
and
sit up and do
listen.
it. You cannot make your own laws, man. You can't do that. So
All right, thank you, Mr. Stallings.
We're gonna reschedule this. I know my rights.
All right,
Reschedule this here.
Mr. Stallings, your case is reset for April at 9 a.m.
All right, April 2nd, 9 a.m. So,
Correct.
Thank you, Your Honor.
All right, thank you.
Okay. Is he wrong? No. He's 100% right. But did he go about it the wrong way? Oh, yes, he did. The guard had his cell phone. He was watching his court case on the guard's cell phone through that little slot. Would I be mad? Oh my goodness, yes. But no, he can't. He can't just fire his attorney and get another one unless he buys one. You know, you get a public defender, you get what you get. You don't tell the judge that you get another one. It's your right. No, they gave you one. But I would be upset too. But yeah, he handled it way wrong because nobody listened to him because he acted so crazy. Okay. All right. Now this one is boring until the very end.
That's right.
All right, well, the request is still denied under 164103. The biggest concern here really is the safety of any person or the community when you're looking at Mr. Spencer's criminal history. And I remember when we kind of first started working with Mr. Spencer, we did give him quite a few benefits, and I knew that there were some issues there. However, now what we're seeing is multiple protection order violations. I'm seeing more than 10 here. It's simply not appropriate to permit somebody with these charges and with this
10.
history to be released with no real great plan. We're set for trial soon in May, and we'll proceed to that unless there's a disposition. And we have another hearing, which is a bond return date at the end of April. I'm not going to in any way modify the bond based on those factors and based on really here any facts indicating the possibility of new law violations if he's released. I think there's a lot of danger, high danger really, that something like that would occur if he is released based on the number of protection order violations that he's been arrested for and convicted of as well. So it's going to be denied. I have considered this. I looked at the criminal history before in anticipation of the bond argument the last time. We will remain set at the end of April for our pretrial conference. Okay, thank you.
Wait for it.
Okay, we will move on to...
I guess you didn't like her rolling.
We'll move on to our 10 o'clock docket. Sorry for that language.
Sorry for that language, YouTube. Don't demonetize me. But they're going to, because, he did shout it out really loud. Okay, so With this next one, I didn't catch the very beginning. They're live, so I get what I get. There's no rewinding. So apparently, she said she was in the hospital during her last case, or at the minimum at the doctor's office, and that's why she didn't appear at her last court date.
Anything you say is being recorded and can be used against you. Obviously, filing a fraudulent letter with the court is a felony. You may want to exercise your right to remain silent. Ms. Burtis, the people's position.
Your Honor, the people have also called and verified, well, I suppose verified the court's statement that the letter provided is a forgery. We called the doctor's office. There's no record. And what we'd be asking for the court to impose a warrant based on that.
All right. I also note that Ms. Stevens has another warrant out for her arrest out of Montrose County for a new felony, class 1 felony drug case. I was suspicious last time that she was not telling the truth. And it appears now that the evidence is coming in that she was lying to the court. She was ordered to be here in person. And so for that reason, her bonds will be revoked and forfeited. Warrants will issue for her arrest. There'll be no bond warrants. Ms. Stevens, you are directed to turn yourself in on those no bond warrants. That's all for today on Ms. Stevens' cases.
Do you think she's going to turn herself in? She already has a warrant in another court for not showing up. But she was in the hospital. So what she did was she took a doctor's name from Utah and said that she was in the hospital in Colorado with this doctor or at his doctor's office or something. They checked it out and they found this doctor in Utah. They called him and they called the hospital that she said she was in and everything. And not only did the judge's staff call, but the prosecutor's staff call. So she was going to get nailed either way. A whole bunch of people were checking on her case. But no, she's not going to turn herself in. Okay, this next one is like 10 minutes long, and it's just interesting. It's just an interesting case.
Ms. Jeffrey? All right, come on up, ma'am. This is 23T173, Holly Jeffrey. I've got Ms. Jeffrey in person pro se. I've got Mr. Zachary on behalf of the people, and we are on for sentencing. So I reviewed the alcohol evaluation. Mr. Zachary, would you like to make a sentencing argument?
Judge, I reviewed the alcohol evaluation as well.
The audio comes back in a second, and you'll hear what you miss here.
Yeah.
No, we agree with the recommendation, Judge. But the level.
It's just this one little part. Don't worry.
I apologize, Judge. We have nothing further to add.
All right, and this was a plea to a DWAI. And given the BAC, it looks like there is a mandatory jail sentence.
It is.
Okay.
What is it, 5 days, 2 days, 10?
So, ma'am, before I sentence you, is there anything that you would like to say?
I didn't want to go to jail,
I know.
but yeah, my BAC was pretty high. So is it local or am I going like clear to Pagosa Springs or whatever? And when would that start? I just got a job.
Okay.
County clerk.
So tell me a little bit about what's going on in your life right now.
So really not a whole lot is going on since I moved from Denver to stay with my mom. And been kind of looking, have applications, resumes. This whole town is littered with it. And I just kind of been sitting, waiting, and finally got that phone call on Wednesday, I think it was.
When are you supposed to start?
I'm already there. I'm on my lunch break.
Oh, goodness. All right.
So I'm currently one of 3 that the state needs for election. So I'm an election.
Okay.
So, I mean, I don't know how it works. Is it possible that after March 6th or so? I
yes.
don't even know that either.
Judge, if I can inquire, I know where I came from, situations like this, they would allow people to serve on the weekends, serve their time.
And
I don't know if that's an option here in Colorado.
I'm guessing
and my
Alabama.
mom is actually
Idea.
going for surgery.
When is she going for surgery?
Surgery's the 18th.
So for DWAI, with that BAC, the 10 days, I believe, has to be
Consecutive.
consecutive. So let me do this. Let me tell you what your sentence is, and then let's talk about how that might play out, okay?
Okay.
So I'm gonna sentence you to 10 days in jail, which is the minimum, okay? I am going to sentence you to 24 hours of level 2 education,
Okay.
52 hours of therapy. I'm gonna put you on an 18-month probation, supervised probation.
Okay.
If you finish your education, therapy, all the things, you can talk to your probation officer about early termination, but it takes a while to get in there and get started. So I want to give you a little cushion so you're not stressed about
Right,
getting all the things
right.
done, okay?
Thank you.
So just understand that if you finish sooner, that's great.
Okay.
But you have 18 months. I'm going to sentence you to 24 hours of useful public service, which is the minimum. And I'm going to sentence you to a $500 fine. I'd also like you to do a mental health evaluation and any treatment
Mm-hmm.
that was suggested
Right.
in the evaluation, okay?
Okay.
So in terms of the 10 days, it needs to be consecutive, but
I know election, I think the last day is the 6th of March. So then I won't be needed again until June for the commissioner's election.
okay.
So if there's any way, actually, I
Okay.
guess we can figure something out.
Well, what's going on with your dog?
Well, since my mom's going to be having this surgery and she can't drive, she can't do anything for 10 to 14 days.
Okay.
So she's actually going to be staying at my sister's house in Denver while she recuperates until she can drive, gets her clear to drive home. So my only concern was, of course, her. And then if her and I are both gone, I have a French bulldog at home, and so I wouldn't know how to work that either.
Okay.
And I know she's coming back like the 2nd or so of April. So I'm really clear to do anything after that.
So I can stay the sentence until what day are you gonna go in? Like
I don't want to go at all. So you just pick
No.
one.
I know.
It would be very beneficial for me if it's like I said, around April 10th, and let's just start on a Monday.
Okay. Well, we start the 15th then
Of April?
of April.
That would be fantastic.
So let's start April 15th.
Okay.
I need you to turn yourself into the jail by 9 a.m.
9 a.m. And where? What jail?
You'll turn yourself in here. I don't know where they're going to be in the process of like figuring out things with the jail here. So
Right.
I would guess that they're probably going to take you over to Archuleta, so you'd be in Pagosa for those
Goes
10
in
days.
It's 10 days, okay.
Um,
So I go here
but you'll go here,
on the 15th at 9 a.m.
uh-huh,
Okay,
and turn yourself in,
okay.
and then you'll start serving your term, and then at 9 a.m. after you're done, they will let
Kick
you
me
go.
out.
Yes,
Get out of
okay?
there, boot me out.
Do you have questions?
I do not. I did a lot of research on.
So you know.
I knew.
All
I
right.
knew it. I was hoping not, but
I'm sorry.
you gotta do what you gotta do.
Okay, so April 15th will
Okay.
be the day you turn yourself in. Is that all
Okay.
right with you, Mr. Zachary?
That's fine with the people, Judge. I also just want to put on the record, there was restitution in the amount of
yes,
$7.
$7.
That's right.
I'm gonna order the $7 restitution.
Yes, I got
okay?
that in the mail. Yes.
And then I'm going to give you this. This is, you probably already got one of these for your alcohol evaluation, but just to contact probation so they can get you set up.
Them, because this last time they actually called me out.
So this time you gotta contact
Okay,
them.
okay.
And I think you have to call the Alamosa office and then they get you scheduled over here.
Okay. Perfect.
Okay? Questions?
No, so $507, 10 days,
Yes.
18 months, classes, evals.
There are also court costs and supervision fees.
Oh, that's right. That's right.
Depending on what your financial situation is, you can talk to your probation officer about the supervision fees.
Okay.
Okay, because depending on circumstances, sometimes they can waive those. Okay.
Okay.
Did I? Do we have a total amount? Okay. I'll have a total amount for you. It's going to be high because it's going to include all the things.
Everything. Okay.
But what I suggest you do is on your way out today, check in at the clerk's office and just get some kind of at least real minimal payment plan so they know you're on top of it. Okay. It
Okay.
doesn't have to be significant because those costs may change. They may go down.
Right.
Okay.
Okay.
What's your French bulldog's name?
Paris. She's a blonde. I would show you a picture, but I left my phone and everything in the car, so.
I have a cream one named Potato.
Potato, how sweet.
Those little suckers are a handful.
Yes, they are. Definitely have a personality, that's for sure.
Okay, that's enough dead space. Okay, so she got to pick her date. Now, no other judge would allow this. I mean, none. Zero. Judges allow you to pick your date when you go in, unless it's something big. But then it's the elections, and that's pretty damn big. Um, but man, I still, election day is March 6th. They could have said, okay, March 7th. I don't care if your mom's going into surgery, your dog, or blah blah blah. No, she got to pick whatever date she wanted. And then, but halfway through this court, watching it right now with you guys, I realized my huge mistake. I don't know if you were on yesterday. Was it yesterday? My last stream. I I played this clip of this court that was too nice. Everybody was too nice. And I told you guys, don't worry, I'm not going to subject you guys to that anymore. Don't worry. I think this is that court, isn't it? I think I got something from that court. But there's more. There's more. So I don't know. I don't remember if it's the prosecutor or the public defender that does this, but he gets up next. And this is how he tries to endear himself to this judge.
115, or 130.
1:15 is fine.
All right, 1:15 on March the 26th. Good luck in negotiations.
Thank you.
Thank you.
You know what the most stolen dog in States is? French Bulldog.
I've got a sticky for you with that other,
She ignored him completely. He's like, your dog's gonna get stolen, ma'am. You got the most stolen dog in the United States. And she just ignored him completely. Oh my gosh. It was hilarious. It was hilarious. She just kept going and he just like stood there like, All right. This next judge, it's only like 4 minutes long. This next judge is a little scary. He's pretty mad.
Well, let me reflect on that, okay? And why don't you come back at 1 o'clock? I'm going to talk to some colleagues about this, and then I'll come back and give you my decision, okay?
Oh, I'm sorry, Judge. First, we have one more thing. It's really just an emphasis, I think. Mr. Thomas never did a misdemeanor.
Don't worry about that. You don't need to hear that. It means nothing.
As, I was in contact with Mr. Chavez once it was extended as well. And he's chosen to accept that.
When was that?
When I was in contact with Mr. Chavez.
Right.
I can't take minutes like I normally do. I couldn't tell the court.
Okay.
I know that very soon after the district attorney talked to me to let me know that she'd be to find a special way to find Mr. Chavez's number.
So I'm sorry, go ahead.
And then once I found his number, I called him. He's always been responsive, so luckily I was able to talk it through with him.
If we would go to trial, what would the people be going to trial on?
The misdemeanors at this point.
And that's what the offer is?
Yes, Your Honor.
That offer. And is the sentencing open sentencing?
Given the probation revocation matter pending, yes.
And you agree, Mr. Chavez agreeing to pay restitution?
Yes.
Ms. Shermer, remind me, when did you take over the docket? And was this Ms. Becker's case before?
It was, I took over the docket, I believe December 18th is when I moved here,
Okay.
I think.
And the case had been worked up by someone else, largely? Okay.
Here we go.
Well, let me talk for a little bit. I don't like taking pleas after the plea cutoff. The plea cutoff is there for a reason. And I know, Mr. Chavez, I gave you plenty of opportunity to take a plea before. Okay? Plenty of opportunities. And you declined it, which you're entitled to. And then I put your trial on my docket to try the case. And I blocked all this time off for that trial. I could have other things there for the trial. I can use and enforce plea cutoffs. I have said this from day one. There will come a time when I'm not going to do this anymore. I'm pretty close right now. I'm pretty close. But I'm going to give some grace here to the DA's office. And my communication to your office, Ms. Shermer, is that don't give the option to produce information you need to prove your case till after the plea cutoff. That's kind of what's troubling here for me. And that may be because you took over, but we have plea cutoffs there. You believe you can prove the case. Sometimes that's not true, but that's my element of frustration. It's not directed at you in particular, but if you were questioning whether or not you could prove that, I think you should have given that person a deadline before the plea cutoff. That's my take. So if I hear that again, I'm probably not going to be that receptive. That said, you're only going to go to trial on the misdemeanor one. That said, He's agreed to restitution. That said, the PD's office isn't ready to try this case probably on Monday. So putting all of that together, I will take the plea. But I ask you to share with your colleagues that I'm not happy with this. I'm not happy with taking a late plea. So I don't know when it's going to happen, but it's going to happen if this keeps up. Mr. Chavez, would you like to enter the plea today?
Yikes. Mr. Chavez, you just ruined it for everybody. Now he's going to say no to everybody else because of you. I hope you're happy. I mean, she should have said, okay, in case you didn't hear yesterday in my last stream, in Colorado, the public defender's office got hacked around the beginning of February. So none of the public defenders have had any access to their computers or cell phones when it comes to work. They don't have Discovery. They don't have their files. They can't text each other. They can't Teams each other. If they wanted something done, they have to write it down on a piece of paper to file something into the court. And if they want to talk about a deal, they have to call the prosecution on the phone and work out a deal. Nothing electronic has been happening. Now it's getting fixed. So today I saw a whole bunch of people talk about how they got their new computers and they have some of their old files. They still don't have Discovery yet. Even today, they do not have Discovery on anything, and they're working on it. If I was her, I would have leaned into that. I would have leaned into that all day long, even if it wasn't true. But she didn't, and then the judge just slapped her down. All right, I can't remember what this next one is. It's 3 minutes long, and I named it harass. So let's see what somebody's gonna get harassed, guys.
Mr. Rex, do you know, okay. I know it's listed as ethnic intimidation, but that might have been an error on the court's part. I don't see a motion to modify the.
I believe that's an error on the court's part. I think we have it as 18.9.111(e).
And delete ethnic intimidation. All right. Mr. Mondragon is charged with harassment, making threats over the phone. It's alleged to occurred on January 16th. He was allegedly high on drugs and bothering the named victim. The defendant believed the named victim was cheating on him, and he appeared to be under the influence of methamphetamine when he was speaking with the officers. Before he left, before law enforcement left, there were several voicemails laid to the law enforcement from the defendant, and heard a male voice identical to Mr. Mondragon's. Some of them were longer than 2 minutes. He called her a whore. He threatened to tell people she has herpes, stated that she hopes she dies and that he would piss on her grave. They consisted of him making obscene statements toward Ms. Mondragon, repeatedly calling her a whore. There were 14 voicemails on her phone on January 15th alone. He also text messaged her in addition to the 14 voicemails. And Ms. Mondragon was visibly upset at the time she was showing the officers the voicemails and the text messages. Mr. Mondragon and the named victim have an extensive domestic violence history. I believe Mr. Rex stated 7 prior convictions, domestic violence related.
7.
One of the purposes of bond is to address victim safety concerns. And here I do have severe community safety concerns. Even though these are just words, they show show what the charge reflects, intent to harass and I am not comfortable modifying the bond and trusting that Mr. Mondragon will not have any contact with the named victim and the protected party. So I'm going to decline to modify bond, not guilty plea will enter, and we'll set this for a pretrial conference. Can I get a date for a pretrial conference?
I usually ask for dates for Friday night, but whatever she likes.
And can we take an oral motion to modify the charge to 18-9-111-1E and just remove the ethnic intimidation, or the people need to file a motion? It just appears to be an error on our part. Yeah. Okay. So I'm going to modify the charge to reflect 18-9-111-1E. And the matter will continue for a pretrial conference on April 23rd at 10 a.m. Thank you.
Okay, I named that right. Harass. Yep. Okay. This next one, don't ask me any questions because I have no idea. None. Here we go.
What does that say?
Best lawyer ever.
It's my.
It's good to see that the deputies have a sense of humor.
Lost in the mail.
My daughter's been taking it to school as her water bottle. She likes that.
All right, let me call 22 CR 3361. The People State of Colorado versus Rafael Ramirez Bernal.
Montana Fay, on behalf of Mr. Ramirez Bernal, he appears in custody by my side with the assistance of a Spanish language interpreter. We do have a proposed disposition. He'll be pleading guilty to a misdemeanor assault under a negligent mens rea. Parties are all recommending a credit time served sentence.
Good morning, sir.
Buenos días, señor. Buenos días. Good morning.
So I've been given a document that states defendant's request to plead guilty in this case. It's my understanding that Ms. Fay went through this document with you.
Sí.
Yes.
And this document is also written in both English and in Spanish.
Sí.
Yes.
And as your attorney stated, that you would be pleading guilty to the charge of assault in the third degree, a class 1 misdemeanor.
Sí.
Yes.
And the class 5 felony menacing would be dismissed. Understand?
Sí.
Yes.
And sir, there's a statement here that says you've been fully advised of your rights. It's my understanding that Ms. Fay went through your rights and that you understand your rights. Is that correct?
Sí.
Yes.
Sir, do you need any further explanation as to your rights?
¿Alguna explicación, algo más de explicación acerca de sus derechos?
No.
No.
And sir, the charge you're pleading guilty to, there's a definition of that charge. Did you read and understand the definition of that charge?
Sí.
Yes.
And that it does fall under a mental state of criminal negligence.
Que cae dentro de un estado mental de negligencia criminal.
Do you understand?
¿Entiende eso? Yes.
So if you plead guilty to that offense, you face up to 364 days in jail and up to $1,000 fine.
364 días de cárcel y una multa de hasta $1,000.
Do you understand?
¿Entiende eso? Yes.
No restitution is being sought in this case.
Pidiendo indemnización en este caso.
And is the district attorney VRA compliant on this?
Abogado, ¿se cumple con los actos de...
Yes, Judge.
Sí, señoría.
Sir, are you presently under the effects of any drugs, medication, or alcohol?
¿Efectos de alcohol o medicamentos?
No.
No.
Are you thinking clearly today?
¿Está pensando con claridad el día de hoy?
Sí.
Yes.
Has anyone forced you or pressured you to enter this plea?
¿Presionado para que se declare culpable?
No.
No.
Ms. Fay waived the establishment of a factual basis?
Yes, para renunciar a los pasos para un fundamento de hechos y su señoría.
Sir, without any questions, how do you plead to the charge of assault in the third degree, a class 1 misdemeanor, under a criminal negligence mens rea, guilty or not guilty?
Culpable.
Guilty.
The court will accept the plea, find that it's been made knowingly, intelligently, and voluntarily, with the full understanding of your rights, the nature of the charge, and possible penalties. Court will accept the plea and enter judgment against you. All right, we can go to immediate sentencing. Any statement made for the district attorney.
Thanks, Judge. Ultimately, we think this resolution is appropriate. We are VRA compliant to proceed. From my understanding, the defendant has been in custody for quite some time. And so I think a credit time served sentence makes sense. It does have some criminal history, but it is dated, with the last one that I see from 2008. Before that, 2003, 2002. So some criminal history, but it's been a while. So hopefully this will create another long stretch without any other instances. Thank you.
Thank you. Ms. Faye?
Weird factual scenario, Judge. The alleged victim in this case saw a truck of his that had been previously stolen in a yard. He approached 4 men who were unloading lumber from that truck very aggressively with his phone, yelled at them all, was videotaping it, yelled at them all that they were going to jail. 2 of those men left after they all tried to talk to this person to see what this was all about. When Mr. Ramirez Bernal left, he got in his car. This guy chased them, jumped into the bed of their truck. They eventually stopped. And then the allegations are that they threatened him with a knife. There was no even allegations that that knife was ever used. The guy did suffer injuries, but they were from jumping in and out of the truck bed. So I honestly think this is just a case of it could have been different depending on who called the police first. He has initially did 54 days of jail. He wasn't arrested on this for a while. And he's now in Arapahoe, and he's been there since last July, dealing with a case there. I'm just asking the court, so he's been in custody a lot longer than 54 days, but I'm asking the court just to grant him that initial 54 days of credit and close this out.
Mr. Ramirez Bernal, is there any statement that you wish to make before the court imposes sentence?
Pido disculpas por lo que pasó.
I'm just apologizing for what happened. That's all.
Okay. All right, sir. Well, what I'm going to do is I'm going to impose a 54-day jail sentence, give you credit for 54 days. I will find you indigent for any statutory court costs and fees that the court can waive. The court will dismiss the felony charge. And Max, make sure that even in the minute order, I want that under stated 3rd degree assault under criminal negligence.
Thank you.
Good. All right, sir. Good luck to you.
I didn't quite understand the way she said it. What happened? What happened? Here's what I think, but I don't know. I honest to God don't know if I'm right. The guy that we just saw was driving around or walking around or whatever and saw his truck that was stolen from him and saw some guys putting lumber in it. And then he went to them to confront them about taking his truck, and then there was a chase. And then I think he's the one that jumped into the truck bed as the truck was moving, and he got injured to get his truck back. And then they said they were going to, stab him or whatever, and then he's in jail because he's harassing and menacing. I don't know. I don't know. But, Cha, you're right. He understands what the judge is saying in English. Almost every interpreter I saw today was answering in, in English. We even waited, one of the courts waited for like 20 minutes for the interpreter to come on, and then he just like answered in English. The judge was highly ticked off. But all right. I think it's this next one. Um, he's not mentally ill. He's just, you might think he might be, but he's not.
More conventional hearing where he would be able to respond to the allegations.
Oh, no, it's not
He might
this
have
one.
an attorney, he might have an attorney, and then we decide if the order stays temporary or gets continued or something else happens. Does that make sense? Do either of you have any?
This one, that nothing crazy happens. It's just so easy. Everything goes so easy in this one that I was shocked.
Questions for me about the procedure?
No.
Okay.
Sorry.
It's okay. We're just making a record, so you got to say yes or no. I'm going to ask each of you to raise your right hand. Do you solemnly swear or affirm under penalty of perjury of law that the information that you are going to provide this court this morning is going to be the truth, the whole truth, and nothing but the truth? Hayden Marcello and Summer Hebert. Okay, and I also want to tell the both of you that I have to take, even though there's similar situations, I have to make a separate finding for each of you. So I may grant 1 protection order, 2 protection orders, or 0 protection orders, but I have to make that separate finding. Does that make sense? Yes?
Yes.
Okay. So why don't we start with you, Miss Hebert? Why do you think you're endangered right now by Mr. Satarsky?
Mostly, I just don't want to hear from him at all anymore. He is like threatening, but
So
Yeah.
how's he threatened you?
I mean, he's like been abusive, but
Like physically abusive with you? Is he he's an ex. Okay. So is he recently? I'm trying not to pry, but I also need to get to it. Is
ago he was like physically abusive.
So you were dating a month ago?
Yeah.
And he was physically abusive a month ago? And he still contacts you?
Yeah.
Have you told him not to contact you?
Yes.
Okay.
Just yesterday.
And what happens?
He called me up a bunch of like random numbers.
Oh, like, did you block him?
Yeah.
And he was still able to navigate that and get to you? And what kind of stuff does he say when he contacts you?
I mean, just right when I pick up, I just hang up because I wasn't sure who it was.
Okay. But he's contacted you over your telling him, leave me alone? Got it. And he was physically abusive to you before? Okay. I am going to grant, do you know whether or not he has weapons?
No, he doesn't.
He doesn't? Okay. I am going to grant the temporary protection order for you. And that protection order is going to be both for threatened physical harm, but also stalking for the repeated contact. I am going to waive the service fee. I'm going to give you some information. You don't have to do anything with this, but this is information on potentially getting attorneys who help with domestic violence cases. You don't have to contact those people. I'm going to waive the service fee because this is an act of domestic violence, and I'm going to give you 2 court dates. You only need to come to the first court date. The second court date just has to do with his compliance with an order to show me that he's relinquished any firearms. Madam Clerk, could you give me the court dates,
We
please?
have March 11th at 3:30 with a PTO,
Okay,
and then March 22nd at 3 for the firearms.
March 22nd at 3. And you don't have to come to that March 22nd. Now, the next thing I want to tell you is he doesn't know about this until he's been served. So the next thing that's going to happen is we're going to hand you a copy of the protection order. It's going to be a number of minutes before we have all the paperwork. And then you'll bring it to law enforcement. You can use a private process server, but most people use law enforcement. And then you provide that information to them, and then they can get him served. he will be present on that next court date. And then we can decide if the temporary protection order continues or becomes permanent, or we have a hearing or something else happens. Does that make sense?
Yes.
Do you have any questions for me? Does he live in Weld County?
Yes.
Okay, so you probably need to talk to the Weld County Sheriff to get him served, not the Boulder County Sheriff. And then you're in Boulder County, correct? Do you have any questions for me? All right, so Mr. Marcello, why are you endangered?
He had been threatening to kill me multiple times and was trying to find me.
Do you know the context?
Because I have been dating Summer since they ended.
Got it.
Said about that.
And then how did you find out that he threatened to kill you?
I was on the phone with someone, and in the background of the phone call, I was on the phone with Summer.
Uh-huh.
And he had been around Summer at the time. And I was on the phone with her, and in the background of the phone call, he was saying, I'm going to kill him, I'm going to shoot him, and I hope you hear that, Hayden, because he knew I was on the call.
Okay, I'm gonna grant the protection orders to you as well. It's gonna be in the same date and time and place, which is 3/11 at 3:30, right back here. Everything is the same for you, except I'm not going to waive the filing fee because this is not an act of domestic violence. And I do not need to set the so-called compliance hearing date regarding weapons. Do you have any questions for me?
No, sir.
And same thing to you regarding service. You will need to contact the Weld County Sheriff if he lives in Weld County to get him served. And this is going to be 100-yard stay away for both of you. Miss Hebert, is it Hebert? Miss Hebert, it's going to be your work, your school, and your home. And then Mr. Marcello, it's also going to be 100-yard stay away for you. And this is going to be your work and your home. Okay. All right, then. It'll be some minutes before the paperwork, and we'll see you on March 11th. And I guess the last thing is call the police if a crime is committed against you. Don't just wait till March 11th. Sure.
How easy was that?
All right. Do we have anyone else here for court this morning?
We do. We have Miss Myers.
It's Miss Myers. Miss Myers, more conventional.
Whoops.
Where?
I mean, I've seen a lot of temporary order cases, and they're much more difficult. They just walked in and said stuff, and that was it. He didn't even ask them very many questions. I just thought that was crazy. That was crazy, easy, and quick. All right, I have one more that's 9 minutes long, and I just love what the prosecutor says to him.
So, Your Honor, first we would ask consistent with the entry of appearance to address bond in all of these cases.
Okay, I should say at the outset, it's my understanding that in cases 23M 134 and 23M 119, the top charge is a misdemeanor 2, which under the statute would require a PR bond. Even though he's currently held on those cases, I think those need to be PR bonds. The other cases do have monetary conditions. Well, they all do, but I think those two need to be modified. In 23M 151, bond is currently set at $500 cash or surety. And in 23 CR 76, bond is currently set at $20,000 cash or surety. So that said, Mr. Hampshire, if you want to address bond, go ahead.
Your Honor, I think the most important piece of information that the court could glean is if the court were to look at a Weld County case, 23 CR 1895, Mr. Kaufman was arrested, I don't know, November 26th, I think, of last year, maybe the 27th, in that case. And until recently entering an agreement in the case, he was in the Weld County Jail held on that matter. That is the thing that caused him to fail to appear before this court on the 5th of December of 2023. And he reports, believably, that he attempted several times in advance of that December 5th court date and subsequently to obtain appearance before this court, notify people to get a video writ. Frankly, I find that believable based on my prior experience in Weld County. Their office, we had a public defender, they didn't even reach out to us to let us know that he needed representation in his Grand County cases, disappointingly. So that we didn't know about him until he arrived here. But he did not voluntarily, fail to appear. Mr. Kaufman is appreciative of the fact that, the court may be pretty concerned. There's 4 cases, and that the court may be a little wary. But the practical circumstances are these. If he gets out on personal recognizance bonds in these other 2 cases, he's going to be living in Granby, Colorado. His mother has a house there, 480 4th Street in Granby, Colorado. She's owned that home for over 30 years. It's paid off. His mother, I guess, is in town now, but typically winters in Arizona or Utah. I think she might be in town to help out her son. And he can stay there. He will be nearby the courthouse. He can get to court personally if ordered. He'll also be subject to the sentence in that Weld County case that I mentioned, 23 CR 1895, 18 months supervised probation on a DF4. He's going to have to report to a probation officer in Hot Sulphur Springs and submit to drug testing. And he'll be working. He's had a good history independently of working, doing heating, HVAC work around Grand County. He believes, although he's been in custody now for a while, he doesn't have anything lined up. He believes he'll be able to obtain employment either working for someone else or getting independent jobs. So he's not going to be on the run. He's not going to be avoiding court. He'll be appearing in court. And then finally, Your Honor, he's very cognizant of the fact that several of these cases involve driving charges. At long last, he's going to be eligible to reinstate his license soon. So Mr. Kaufman is very, very concerned not to get any more driving charges because he would like to be able to square things away so he can live life and support himself doing the kind of work I just mentioned when he's properly licensed and insured. So that's his request, personal recognizance bonds in those 2 cases. Thank you.
I just think listening to that public defender is punishment enough. You can let him go now.
Ms. Dodo.
Thank you, Judge. So we would object to bond modifications on or in 23 CR 76. This is a case where the defendant is charged with a class 4 drug felony for the possession of fentanyl. I know this court is very familiar with Mr. Kaufman, mostly because he's been in front of this court basically always for traffic. He has a DUI from 16, DUI from 17, DUI from 18, disorderly from 2021, and a DUR from 2021. He has FOJs, both from 2022. I think it's nothing short of delusional that he would think that he would be eligible for a license with multiple HTO cases open, multiple DUR outs. I know that the DMV changes the regulations all the time, but Mr. Kaufman simply cannot drive, and it's something simply he doesn't understand. He keeps driving in this community. He's not insured. He doesn't have a license. He's HTO. He's DUR out. He doesn't have plates. And now we're coupling fentanyl with that. So he has drugs in both 23M 151. He had under a gram of fentanyl. And then we're picking up the felony case where we have felony level fentanyl. And it's pretty clear to this, at least to the people, that he can't abide by those restrictions on his driver's license, and his continual picking up of new cases of concern. So we'd ask the court to deny bond modification in 23 CR 76.
Thank you, Ms. Dodo. So first off, I am going to modify the bonds in 23M 134 and 23M 119. I don't think, based on what I said earlier, he can be held on those. They're currently set at $500 cash surety each. They will be modified to $500 personal recognizance in each case. Regarding the other two cases and bond modification, I do have concerns about Mr. Kaufman's likelihood to appear in court. He's failed to appear in each of these cases at least a couple of times. He also has those FOJs mentioned by the people. I also do have concerns about community safety. I mean, the reality is that Mr. Kaufman didn't appear for court back in December because he got picked up on another charge, another felony drug charge. The bond was set in that case apparently at a point that he couldn't post, and that case resolved. Well, all four of these cases have been pending for a very, very long time. But the idea that Mr. Kaufman getting arrested for similar charges in another jurisdiction, that gives me concern about community safety. And I do think under these circumstances that the bond is reasonably set, and it'll remain set at $20,000 cash assurity in 23 CR 76 and $500 cash assurity in 23 M 151. And we'll need to reschedule these cases for another court date. Mr. Hampshire, do you have a request on when we do that?
Could we come back next week, please?
Yeah, I can put this on for 1:30 on March 5th.
That works, thank you.
All right, 1:30 p.m. March 5th for Mr. Kaufman's cases. I think that's all for Grand for the moment.
So, that's all I have for today. I had one more that's really good, but I forgot to prep it. So it's not in my little prep area, but that's okay, because you know what that means? That means tomorrow I already have some stuff ready. So I don't have to work so hard tomorrow to get enough content. But it is really good. But thank you so much for coming out today to watch our Colorado craziness. I don't always do Colorado. Okay, we had that one video not too long ago with Magistrate Fink, I think, or Judge Fink. I think it was Magistrate Fink in Indiana. And it was the best I've ever seen a judge ever in all the court cases. That one court case. So I've been wasting my time on this guy, watching him. He's not on every day. He doesn't have court every day. And I was just about to give up on him. But today, I watched him again, and his first case was a guy who was apologizing to Judge Fink for the way he spoke to him last time. Because apparently, and this was, I think, 20 days ago, so I didn't get it. It was 20 days ago. Apparently, 20 days ago, he was disrespectful to Judge Fink in his court. And the reason why I know it was 20 days ago was because he's been in jail that whole time for contempt of court. And he had to write a letter of apology. So I'm going to keep looking for classic Judge Fink. He's been just so nice and easy lately. Nothing, it's all boring. Here, I'll show you. I wonder if it'll play. No, it won't. Yeah, well, I'll show you. Let me show you. I think this is him here.
9.
And this is the guy who apologized.
Mr. Timmons appears by video and with counsel attorney Ryan Beal in person.
And Judge, there was a contempt case.
Correct.
Mr. Timmons indicated that he'd sent over an apology letter. Correct. And I e-filed it as well. So I'm hoping that the court will forgive that so we can use his credit time towards
Correct. So the plea agreement as it stands now, the way it's written, it does take into account that credit time.
It does, Your Honor.
All right, under 46 DO4 2310 MC 2834, court previously found Mr. Timmons in contempt of court, sentenced him to 90 days in Port County Jail, but advised him that he made a written apology to the court that would purge himself of the contempt. Court does note that on October 25th, 2023, Mr. Timmons did write a letter of apology to the court, which the court accepts and now purges Mr. Timmons of contempt in 2310 MC 2834. For whatever reason, the court didn't receive that until February 19th, 2024. However, any time served on the contempt sentence under MC 2834 is now available, and Mr. Timmons is eligible to use that towards any time in F697.
So he gave the time that he was in there for contempt to the other case, but he didn't, lecture him or anything about what he did in court last time. So I don't know what he did in court last time. Judge Fink usually, he hits hard, but he's not lately. He's just been a robot, a strict judge. They come before him, he sentences them. That's it. But I'm gonna keep, yes, no. What he can use all those days for is for the case he's originally in jail for. So he got arrested. He came in front of Judge Fink in October for something or another, and he made an ass of himself in Magistrate Fink's courtroom. So he got 90 days of contempt of court. But it's not concurrent with the first charge. So now that he wrote that apology letter, all the days that he's been sitting just for the contempt of court, all of those days he can use towards whatever he was arrested for to begin with. I didn't even care. I don't know. They probably said, but I wasn't listening. Oh, her. Yeah, I know who you're talking about. This is also Magistrate Fink. Oh, no, it's not. It's Link. I can't read that. It's too tiny. Someone with better eyes tell me if that's Fink or Link. I think it's Link, Link. No, this guy is amazing. He sentenced this guy right here 90 days for contempt of court. We see people every day swear at the judges and talk and scream and don't let anybody, they just don't follow any court rules at all. And they never get contempt of court, ever. This guy, this magistrate, we'll just call him Ink, because I don't know what that little freaking letter is because I can't see it. This guy, he won't allow it. I'll just put you right in jail. So I'm going to keep watching him to get more of him. I have him in another stream not too long ago, and it was amazing. Maybe I'll search for it real quick and put it in the description. Yeah, I will, because he's my favorite. He's better than them all. All right, guys. That's all I have for tonight. I will talk to you again soon. I hope you guys have a good night or morning or whatever it is, wherever you are. See ya. Thank you so much for coming.